In 2020, two companies spent more than $200 million on a single ballot measure in California, the most expensive in the state's history, more than double what had ever been spent on a ballot initiative there before. They weren't trying to elect anyone, they were trying to write their own labor law, put it directly in front of voters, and get it passed before a court could force them to change their entire business model. By the end of this video, you'll see why a law the companies wrote and paid for themselves is now the thing they're being sued over. The companies were Uber and Lyft, joined by DoorDash and Instacart, and the law they were racing to escape was called AB 5. Passed by the California Legislature in 2019, AB 5 used a strict legal test, sometimes called the ABC test, to decide whether a worker counts as an employee or an independent contractor. Under that test, a worker is presumed to be an employee unless the hiring company can prove the work happens outside its usual business and that the worker operate their own independent trade, doing similar work for others. For rideshare drivers whose entire job exists inside the company's core business of arranging rides, that test was brutal. It pointed almost directly at employee, a label the companies had spent a decade building their entire cost structure around avoiding. That distinction matters enormously. Employees are entitled to minimum wage for every hour worked, overtime, unemployment insurance, and workers' compensation. Independent contractors get none of that automatically. In August 2020, a judge ordered Uber and Lyft to actually reclassify their California drivers as employees, and both companies publicly threatened to shut down their entire service in the state rather than comply, going so far as to prepare public statements warning riders their apps could simply stop working within days. Instead, they went around the legislature and the courts entirely and appealed straight to voters. The $200 million campaign became Proposition 22, a ballot measure custom written to carve rideshare and delivery drivers out of AB 5 permanently, while offering a smaller set of company-designed benefits instead, a guaranteed minimum earnings rate set at 120% of the state minimum wage for active driving time only, not the waiting time in between rides, a partial healthcare subsidy for drivers who worked enough hours per week, some occupational accident and injury insurance, and a promised process for drivers to appeal being kicked off the app. In November 2020, it passed with 58% of the vote. One detail researchers would later flag as unusual. No single state agency was ever formally assigned to monitor or enforce whether companies actually lived up to those promises. Enforcement was left almost entirely to drivers willing to sue. That should have ended the story. It didn't. In 2021, a state court judge ruled Proposition 22 unconstitutional, arguing it illegally stripped the legislature of power it wasn't allowed to give away, since only lawmakers, not voters, are supposed to control the state's workers' compensation system. An appeals court reversed that ruling in 2023, siding with the companies. The fight then went all the way to the California Supreme Court, which unanimously upheld Proposition 22 in July 2024, 4 years after it originally passed, closing off the main legal path that could have overturned the entire law at once. Company shares reportedly jumped in after-hours trading the moment the ruling came down. Here's the twist almost nobody expected once the dust settled. The companies are now being accused of not following the very law they spent $200 million writing for themselves. In April 2026, a driver advocacy group called Rideshare Drivers United sued Uber directly, alleging the company never actually built the appeals process. Prop 22 promised the same process the ballot measure's own text described as a required protection for drivers who get deactivated. Under the law, that promise is an optional decoration. Prop 22 only allows the independent contractor classification to legally stand if companies actually deliver the specific protections written into it, which means an unenforced promise isn't just a broken one, it's potentially a broken foundation for the entire arrangement the companies fought years in court to protect. One driver named in early reporting, who had driven for Uber and Lyft in the Bay Area for 8 years, said he was deactivated right before Christmas after braking hard to avoid hitting a pedestrian who ran into traffic, causing his passenger to fall out of her seat. He said he was never told which passenger complained or given any real chance to explain what happened, only that his account had been shut off. He now works as a security guard and drives for Lyft occasionally, calling the sudden loss of income something that turned his life upside down. With no unemployment insurance to fall back on, since contractors don't qualify for it, and no clear answer, even now, about what he supposedly did wrong. And that's not the only legal exposure still sitting on the table. Separately, California's Department of Justice, along with the city attorneys of San Francisco, Los Angeles, and San Diego, filed a joint lawsuit seeking back pay for drivers covering 2016 through 2020, the years before Proposition 22 existed at all, when the companies were arguably already violating the state's existing employment law. That case alone could be worth billions of dollars if it goes against the companies, and as of 2026, it's reportedly moving toward mediation rather than an immediate trial, with a trial-ready deadline set for 2027 if settlement talks fail. Drivers rallied outside city halls in early 2025, specifically to keep public pressure on state and city officials not to quietly settle the case for less than they believe drivers are owed, with organizers arguing that a settlement negotiated quietly, out of public view, tends to favor whichever side has more lawyers and more patience. It's worth being fair to the other side of this. Uber and Lyft have both pointed to their own driver. Surveys showing a majority say they prefer the flexibility of contractor status over a traditional employment relationship, with one Lyft survey claiming more than 80% of California drivers said Prop 22 had been good for them personally. The companies argue reclassifying more than 1 million people as employees overnight would have forced steep price increases or a full exit from the California market entirely, which would have cost many of those same drivers their income altogether. That argument won over 58% of voters once already, and it's part of why Prop 22 has survived every legal challenge aimed at striking it down completely, rather than just tightening how it's enforced. But surviving a constitutional challenge and actually delivering on your own promises turned out to be two different fights. A law written by the companies it regulates, funded at a record-breaking price, upheld by the state's highest court, is now being tested by the much simpler question of whether the people who wrote it are following their own rules. Separate California legislation covering worker pay violations more broadly has also tightened in 2026, adding new penalty structures for companies that misclassify workers and don't proactively fix it. Though attorneys who track these cases note that a company built entirely around treating its workforce as contractors has little room to claim it was already correcting the problem. Prop 22 was designed to settle an argument about what a driver legally is. Whether it actually protects the people driving is still 6 years later an open case.